All right, good morning, agents. This is Kevin Lauren, I'm the Director of Training and Marketing here at Alta Realty Group, and today is our last webinar of the year. And we're going to be joined by Lauren Noack, and she's going to go over the car changes. There's been a few changes to the car form, so we're going to have Lauren join us today. Before we get into our presentation, I'm going to bring Bill Seitz, corporate broker, onto the line. Good morning, Bill. How you doing today, buddy?
Hey, good morning, Kevin. I'm doing great. How are you?
All right, a little under the weather, but it's going to be okay.
Sorry to hear that. Is it raining up there?
Oh yeah, it's raining like a dog. My street looks like a river.
Yeah, I don't think there's any one of us wherever we're located today that's not being impacted by the weather. So it's kind of a nice change, though. I don't mind it, to be honest.
Hey, winter's here. It's great.
Mm-hmm. That feels seasonal for sure.
Love it.
But I wanted to, yeah, good morning to all the Alta agents. Thanks for joining us on our last webinar of the year. What better way to finish off the year with some legal forms and changes to our industry as we move into 2024. So
Sexy stuff, huh?
yeah. Well, we gotta do it and keep on top of it. And so I appreciate Lauren for coming on. But yeah, we have some nice mortgage updates, and I know Debbie has a brief one for us. So let's get her on, and we'll move into the meat and potatoes of this thing.
Perfect. Let's bring Debbie on the line. Debbie Saccone, good morning. How you doing today?
Okay, I remembered to unmute this time.
Yay!
Last time I was having a conversation with myself, apparently.
I do it all the time. I get it.
Oh my gosh, I am so ecstatic out of my mind. It's so many good things are going to be coming up in 2024. And already I am telling you, I priced a loan this morning just to be able to let you know like where the rates are right now for just a basic loan conforming, not high balance. Let's see what my loan amount is. Okay, so 650 purchase price, 455 loan amount, good credit score. We are hovering. This is with no origination points. Okay, we're hovering just a tad over 6.375%. Actually, and might even be able to get 6 3/8, and maybe with another lender 6 1/4. That's just for just a no frills basic loan. It is awesome. Of course, we still can do the buy down, the 3-2-1 buy down, 2-1 buy down, and the permanent buy down. But I just want to leave you with a really quick thought, because I love talking to my coach every other week, because he always reminds me, not that I always need reminding, but it's just good to have someone that's like rooting for you, remind you what you're thinking is what you're going to bring into your life, manifest into your life. So just make sure to keep thinking good thoughts and positive thoughts, and picture yourself where you want to be. And I also want to give a shout out for Tasha getting a deal in escrow. Woohoo! And Sandra's working on it. And I'm curious to see if that offer was accepted. But I really appreciate all the Alta realtors that are reaching out to me on a regular basis. I'm always available to answer questions. And thank you, Tasha. um, even on weekends. And also, listen, you know what? Who is going to buy a house during Christmas and New Year's? I'll tell you what, there are people that are buying a house during Christmas and New Year's. I bring my laptop everywhere, and I try to answer every single call that I get, unless I'm on the other line. So if you have something going on, you have an offer that somebody wants to make for their Christmas present, just don't hesitate to reach out to me. I am available all the time. So I just want to leave you guys with happy holidays and happy frickin' 2024.
Oh yeah, darling. Here we go, right?
All right. Take care, you guys.
Thanks so much, Debbie. Love your enthusiasm and really appreciate what you do for our company.
Yeah, just to that point, Kev, that's really cool that Debbie priced out that loan this morning because, you know, as it's being a little bit slow, you know, I'm not in there pricing things out every day anymore just because I'm just not that as busy. But, you know, obviously on a macro level, watching the 10-year drop, I actually this morning was already sending out updates to one of Rhonda Butler's clients and also a client of mine that just missed out, you know, on the escrow fell out because of it was a seller issue with water damage, but that's a whole nother issue. But just reminding them, you know, we always talk about this stuff, like to hear that, you know, a conventional loan now is in the low sixes is amazing. It was 8% 2 months ago. So once again, as more and more people find out the trajectory is going down, more and more buyers enter the market. They can always refinance later, but if you're competing with all these new people that are coming back into the market, it's going to be much tougher. Is while the inventory is still somewhat limited until it opens up, it's still going to be challenging to get offers accepted. So, you know, my advice would be if you have someone that is interested in seriously buying, get them, tell them this is the time. Like Debbie said, people are buying homes through the holiday process. A lot of people don't want to do it, but think outside the box, be the opposite person. Now's the time to get in, and you probably going to qualify for more house too now that rates have dropped. So just another firm reminder: be the person that's proactive and getting out there and you know, conveying this information.
For sure. That's how we get business. We are communicators. We talk to our agent or our clients and we let them know what's going on. That's how we build value. So that's a great point, Bill.
Cool. Well, let's get
Well,
Lauren on.
absolutely. Why wouldn't we? All right. Well, now we're going to switch gears. We're going to bring Lauren Noack, our compliance manager and the owner of TC Advantage. Good morning, Lauren. How are you doing today?
I'm well. Thank you so much for having me.
Yeah, always a pleasure to have you on our webinars, Lauren. So I believe I've made you panelists, and would you like to share your screen with us?
Yes, I would.
All right, I'm going to stop my share, and you can have the reins.
All right. Let's see here. Haven't done this in a while.
I know, right? It's been at least a month of Sundays.
Okay. So let me share my screen.
All right, golden. We can see it.
Cool. Okay. So, welcome everybody. Thank you again for having me. I love doing these webinars for everybody, so I'm happy to be back. Before we get started, I just wanted to introduce myself. As already mentioned, my name is Lauren Noack. I'm the owner of the TC Advantage. I've been an independent transaction coordinator for over 10 years. I'm also a licensed real estate agent. I am CAR certified as a transaction coordinator and also as a forms trainer. What I am not, however, is an attorney. So we're going to be discussing a lot of the new laws that are taking effect next year. So this is kind of my disclaimer that this is not legal advice. You should always consult with your broker and CAR Legal with any of your specific questions. I'm just sort of passing along what I've been learning so far. Okay. I don't have a ton of time today too, so we're going to be going through these updates pretty quickly. There were over 900 new laws signed by the governor, but we're just going to be talking about 10 that are really kind of real estate related. Then we'll talk about one new CAR form, as well as some revisions to transaction property management forms. And then if we have time, I'll touch on a few silent revisions that you'll be seeing as well. So this first law was actually sponsored by CAR. And the goal was to make it easier to identify if a property is in a high or very high fire severity zone from just the NHD statement or signature page alone. Currently, you would have to kind of delve in a couple pages to get some of that information. So now they've added 3 new subcategories into the initial statement or signature page. And that is the FHSZ stands for Fire Hazard Severity Zone. So you have the option of high fire hazard severity zone, that's the state responsibility, the very high, that's a state responsibility, and then a very high, that is a local responsibility. Because local agencies, so your cities or your counties, at their discretion can adopt fire hazard zones that aren't necessarily identified on CAL FIRE's fire hazard severity zone maps. So that was the one element that was sometimes kind of hidden a little bit in the report. And then if the property is located in any of these 3 zones, that yes box is going to be checked. And assuming it's a residential 1 to 4 unit property and it is not exempt from the TDS, then you would need to bring in that FHDS form, and that would be required as part of the transaction. And that's the fire hazard and defensible space form that nobody really knows how to use, and they keep changing. So this is how you know if you need to use it.
I like this update, Lauren.
Yeah.
I think there was some ambiguity on a lot of properties, and I think agents and even sellers, didn't know where they, what I mean? So I think this makes it a lot clearer.
Yeah, 100%. So all the NHD companies are on board. And I'm sure you've been already hearing about it from them as well. And so I think this will be something that will be a little bit easier to note, since California is one giant matchstick. So this is a new law specifically addressing flippers and what they will be required to disclose. So who's considered a flipper? According to the law, any seller who accepts an offer within 18 months from the date when title was transferred to them. So something to keep in mind is that this is part of the TDS law. So all of those same exemptions and cancellation rights apply, meaning if a seller is exempt from filling out the TDS, then they're going to be exempt from these disclosure details, right? So like if you are a successor trustee and you're like, I just got this property 5 months ago, I'm not a flipper. You're not, because you're exempt from filling out the TDS. And so you're exempt from these details. What are the details? The seller or the flipper in this case must disclose any repairs, renovations, room additions, structural modifications that were performed by a contractor with whom the seller entered into a contract. Now, the law also does not specify a written contract. So verbal contracts are in play, and that's something that everybody should consider in the implementation of this law. The seller also must provide the name and any contact information for the contractor or contractors for any work that was done over the amount of $500. And then the seller must disclose any permits obtained. So if the seller wasn't the one to obtain the permits, if their contractor did, or a third party or whatever, they must provide to the buyer the contact information for the third party so that they can provide the permits. This law goes into effect July 1st. So that means we're going to see updates to the TDS and the SBQ in the June forms release that are going to address this specifically. But I don't think it's going to be any kind of standalone form or anything like that. And it's probably not going to really change the day-to-day practice of agents, because a lot of these elements are already required under the law. You have to disclose permits if you have them. You have to disclose repairs if you have done them. But this is just a little bit more transparent in providing that contact information and some of those details. So it's important to know this information now if you are or are working with a flipper, to kind of keep this information handy, because as of July 1st, they'll need to be disclosing that.
This is definitely a little more robust, Lauren.
Mm-hmm.
It's a little more in detailed. I think they want to make sure that, there is maximum disclosure. And I know there's a lot of agents with the brokerage that do work with flippers and investors. So this is something to keep an eye on, and we will as well.
Yeah, absolutely. This next law has been talked about quite a bit, and it was created as a preventative measure against predatory listings that they were seeing on the East Coast. So what would happen is agents or brokers would find sellers and pay them like a nominal fee, like $300 or something, to list their properties for a crazy length of time. Like they were seeing like 30 to 40 years for these listings. And they would take an exclusive listing and then they would record that exclusive listing. And then essentially sit back and do nothing and hope the seller forgets all about it. And then a couple years go by, 7-10 years, the seller sells their property. They forget all about this other broker because this broker hasn't followed up with them. They haven't tried to sell their property. They haven't done anything. They go with another broker, maybe they sell their property. Now this original broker comes back and claims the commission. Why a seller would agree to this in the first place, I have no idea. Maybe they needed the couple $100. But obviously big scam, super predatory, and the state wanted to kind of get ahead of it. So now we have this law, and it caps the length of a listing at 24 months from the date made. And the last couple years, things are selling as the ink on the listing agreement is drying. So it conceptually, it's kind of hard to think about a 24-month listing. Nonetheless, that's what they've capped it at. So it's important to distinguish the 24 months from the date made, because if you take a 24-month listing, right, but it doesn't maybe go into effect for 2 months, right? So the date prepared is one date and then the start date is 2 months, or maybe there's a delay for for prepping the property or anything like that. You essentially have like a 26-month listing, which according to the law makes this listing unenforceable, unlawful, and void. So they covered all their bases in saying it's not worth the paper it's written on. There's also some gray area on this law when it comes to the reservation period. So the reservation period is that section on page 1 of the listing where you can state how long after the listing expires. If you have, a list, maybe you showed certain buyers the property, and if any of those buyers on that list purchase the property after the listing expires, then you're still entitled to that commission. So does that period count towards this 24 months? They're not really sure. So be really conservative and keep that in mind when you're taking these listings. Again, this is for exclusive listings. This is for residential listings. And then there's also in this law a 12-month cap on any extensions to these exclusive listings. So they're just really trying to kind of close this loophole of making these extensions for crazy periods of time, with the goal of trying to get people to forget about them.
I can get behind all this stuff, Lauren. This seems like a good framework for that. I think most people would never even consider
are okay with it.
Yeah,
exactly. So the law also makes it void and unenforceable any kind of automatic renewals or recording of exclusive listings, and that is including 5 or more unit properties, and that's regardless of the length of your listing. So if you take a 3-month listing or a 1-month listing, as I've seen before, you cannot make it automatically renew. So keep that in mind, that this is in addition to this law about a cap on the listing period, there's also language that makes automatic renewals unenforceable and void. So this is the change to the listing agreement, and it's it's literally an asterisk and a little added paragraph that brings that kind of to the forefront, that you can't go past 24 months. I know a lot of people with the current litigation about commissions were expecting something more, but that will probably be coming in the June update once they have a little bit more time to process all of that. So stay tuned for changes, big changes to the commission structures on listing agreements in June.
Yeah, we kind of touched on that last week, Lauren, just kind of briefly about changes that are imminent, and also how California law is a little different than some other states.
Yeah.
So there is some protectionary measures in the contract. So
Correct.
it's not every state is uniform in their exposure, but I'm sure they want to get ahead of this. So yeah, that'll be definitely something to keep an eye on.
100%. And I'm also happy to come back and discuss the buyer representation agreements and how to use those. They've been updated, how to ask the seller to cover any extras. I think we're going to start seeing a lot of kind of changes and shifts in that department. So there's a lot to discuss in there.
I would say if while we're on that topic, let's just plan that for one of our January. I can get with you on the date, and let's definitely make that a priority, because I think a lot of agents, including myself, when I was doing day-to-day sales, my clientele was usually referral, most of the time wasn't people that I knew, so I didn't really want to use that form. I think a lot of people feel the same way, but considering where we're at in the industry and what's happened, I think we all kind of have to change our thinking on that and start using it and learning to use it. So I think that'll be an awesome webinar for next year or
100%.
next month. Next month.
I think well, both.
Next year and next month.
There's definitely a lot of advancements and new ways to kind of have those conversations with clients that directs the conversation in a more kind of protective light of the agent and your time and your value. And that we'll definitely do that for sure. So these next three laws, I just kind of wanted to touch on briefly. Currently, California notaries are not authorized to conduct their notarization online, which kind of surprised me, because I personally used an online notary and I didn't even realize that they were out of state or had to be out of state to do that. So the notaries that are out of state, they're currently kind of recognized de facto, but as of January 1st, they will receive clear recognition by the state as long as the notarization is conducted in accordance with the laws of their jurisdiction where they're commissioned. But as for our own California notaries, this law will essentially come into effect once the Secretary of State certifies the necessary technology. It shouldn't be an issue because the technology already exists. And like I said, it's being used in other states. So hopefully it won't take long for the Secretary of State to do this, but the authors of the bill were smart and they put in a little deadline of 2030. So whichever happens first, hopefully we don't have to wait until 2030, but this is definitely a move in the right direction. I think it will help also just kind of put everything online where it is already. And this is just one more element of that. The next update is an increase to the small claims court limits. Now natural persons can claim up to $12,500. Non-natural persons can claim up to $6,250. So what does that have to do with you? Most buyer and seller disputes that can't be settled often end up in small claims courts. And that usually includes claims over the deposit and the earnest money deposit. So if you're dealing with deposits in this price range or kind of in this new gap between the old and the new, this is something that you should keep in mind. It's also important to pass along to your clients this update because the CAR contracts specifically exclude from any mediation or arbitration requirement claims within the jurisdiction of small claims court. So something that would previously have gone to binding arbitration may now get kicked down to small claims court because it's within this small claims amount. So you're only dealing with the mediation arbitration requirement claims if it's too much to be handled in small claims court, if that makes sense. And finally, this new law, I just find the most entertaining to me. This was also a CAR-sponsored law, and it's to update that homeowner's guide to the environmental hazards booklet. Some of you OG agents may remember that back in the day, this was the thick booklet. I think you can still find them in some of the local association, like back offices. But I just used to always remember it was just this huge, heavy book of, I don't even know, because most people didn't read them. But
Yeah, I
it's
remember
all
those days,
online
Lauren.
now. It's a link. The digital booklet gets automatically provided with the NHD reports. So everything's digital. Again, no one ever really read them before. And now that they're digital, I'm like 99.9% sure people really aren't reading them. Even though this is a statutory disclosure and both parties have to sign off on a receipt that they've received it and read it. So anyway, this update adds 3 new chapters to this booklet. And they were added to provide some valuable information to consumers regarding the risks of wildfires, climate change, sea level rise. A lot of the coastal communities are dealing with that. And so in an attempt to cut down on, quote, wasteful government spending, CAR wanted to make sure that the bill didn't cost anything to implement. So there's no allocation for funding this update. The funding, I guess, is going to come from existing resources or private resources as they become available. And because of this kind of undefined way of funding this update, there's no firm deadline for when the update is due and when it needs to be done by. So we'll see it maybe someday. I don't know. It's kind of vague. So there you go. I'm glad we did that. Okay, this 7th law we're going to talk about, I'm really interested to see how this is going to play out. Interested, terrified, kind of go back and forth. But basically ADUs can now be separately transferred as condominiums, according to this law. Last year, I think there was something put on the books allowing for separate conveyance of an ADU. But that was a Habitat for Humanity bill that talked about like deed restricted affordable housing. This new law has the potential to apply to all ADUs. So in order for the average Joe to transfer their ADU as a condo, there are a lot of conditions that have to be met. So first and foremost, the locality, right? So the city or the county has to adopt an ordinance that permits the separate conveyance of ADUs. So if your locality doesn't accept or adopt this ordinance, then you can't do it. Next, the ADU has to be transferred as a condo. And the process to establish the condo has to comply with the Davis-Sterling Common Interest Development Act. So you'd essentially need an attorney for this to create CC&Rs. You have to file a declaration. It's just pretty legally involved. And you may just end up essentially as a 2-unit association. Then you also have to comply with the Subdivision Map Act, which also has a lot of hoops to jump through. And that comes into play anytime you want to split up a property. So, and then there's also a condition that says if there's any lien holders on the property, they have to give their consent to establish this ADU as a condo. And if they want to, they can require their lien to be paid off in full or modified as a condition of providing their consent. And then finally, if the main property is already in an HOA, then the HOA also has to provide consent or approval of creating this condominium. But in theory, you can make your ADU and sell off that chunk and make it its own separate condo and sell it. So we'll see. It's going to be really interesting if this starts getting implemented and what those transactions look like.
Yeah, and to that, Lauren, I know there's a lot of talk about that here locally in Costa Mesa and Newport Beach, but I don't think they've really outlined the process yet.
Mhm.
And so I think for anybody who might be working with buyers that are saying, "Oh wow, this is going to be great. I'm going to do this and this, and I'm going to put the ADU on. I'm going to split." You got to be
Yep.
very careful that you know exactly what each city or each municipality is requiring to do this. I mean, obviously, there's potentially for a lot of problems, and
Mhm.
just be clear on what your locality is demanding of you.
Yep, exactly. So, yeah, so I think that's going to be really interesting. Okay, these last three laws are all regarding landlord or housing provider, as they're now called, but that takes up a lot of space on my slides, so just gonna still call them landlords. Landlords and tenants. So the most publicized is this one regarding limits to the amount a landlord can collect as a security deposit. This law goes into effect July 1st, so you could probably expect to see a whole new form or an advisory in the June release that specifically addresses this. The law states that the housing provider can collect only 1 month's rent as the security deposit, along with a first month's rent. And it doesn't matter if the property is furnished or unfurnished. There is an exception to this, and that is for small landlords or like mom and pop landlords. They can collect up to 2 months' rent as the security deposit in addition to that first month's rent. So, what is considered a small landlord or a mom and pop landlord? A natural person who owns no more than 2 residential properties that together include no more than 4 units. So, for example, a landlord who owns a single family home and a triplex would be considered a small landlord. The car attorney also brought up the law doesn't specify if the properties have to be in California. So it's best to take it as a literal translation of 2 properties total. It doesn't say the 2 properties in California. Also, a family trust can qualify as a small landlord, and even an LLC can qualify as long as every member of the LLC is a natural person. Of course, there is an exemption to the exception, and that is for service members. So if the prospective tenant is a service member renting from a small landlord, then the security deposit is still limited to just 1 month's rent. You also may be wondering about security deposits that have already been collected that go over this limit. The law specifically addresses that and allows the landlord to retain that deposit. And since this doesn't go into effect until July 1st, the landlords can continue to collect and keep the security deposits that exceed these limits, in theory, up until June 30th. So, the other thing to keep in mind too is that under California law, it doesn't matter if you call deposits different things. Like, you can't, if you have like a security deposit and a pet deposit and a cleaning deposit, those all under California law fall under security deposit. So those all count towards that amount of the first month's rent, or 1 month's rent or 2 months' rent. The next law is in regards to screening tenants. Section 8 tenant or anyone receiving like a government's rent subsidy must be offered the chance to have their application reviewed on the basis of their ability to pay, as opposed to their credit history. So if a prospective tenant opts for this option, then the housing provider has to allow a reasonable time for the tenant to provide their alternative evidence. That can be government benefit payments, pay records, bank statements, and the housing provider has to reasonably consider this information. So they can't just be disqualified or only considered based on like their credit score. They have to be able to show their ability to pay. And of course, as a Section 8 tenant, their rent is subsidized. So they're only paying a portion of this full rent amount, which means they only have to give evidence that they have an ability to pay their portion of that rent. as sort of a bone thrown to the landlords in this situation, the housing provider can still ask for other information or documentation to verify employment, request landlord references, or just verify the identity of the person as well. And then finally, the last law here is a bit beefy. We may even need something separate to kind of go over these again. But here we go. So the Tenant Protection Act, or the TPA, is California's statewide rent cap and just cause eviction law. It's not a COVID-related law. This was actually in place prior to COVID, well, barely, like January of 2020, I think. But this law makes some updates, or gets some updates, and those updates go into effect in April. And these are meant to tighten up the requirements for landlords doing no-fault evictions. So currently a landlord can evict based solely on, in the case of an owner move-in no-fault eviction, based solely on their intent to move in. So they just tell the tenant, hey, I'm going to move into this property. You got to go. Now this new law requires the landlord states the name and relationship of the person moving in. They must inform the tenant that they can demand proof of this soon-to-be occupant owning the property or being related to the owner. And then the occupant has to move in within 90 days after the tenant vacates and has to stay there for more than 1 year. If this occupant doesn't move in within 90 days after the tenant vacates and or doesn't remain for more than 1 year, the owner has to offer the unit back to the tenant under the same terms that they were under before they were evicted, and pay for reasonable moving expenses in excess of any relocation assistance they paid initially. So if they pay their tenant to move out, that doesn't go towards having to pay for these moving expenses to move back if they don't meet those other two requirements.
Wow, that's
Eviction,
a crazy one.
Yeah. So it's yeah. Eviction based on substantial remodeling is even more restrictive. It's already fairly restrictive and like what is considered. Currently the landlord can evict if the remodel will take more than 30 days. But this new law says it has to be more than 30 consecutive days. So if at any point a tenant could reasonably continue living into the property without violating any health, safety, and habitability codes, then those 30 days restart. So maybe you are waiting, maybe you have, you're waiting for your final permits or something, right? But the property doesn't violate any health codes or safety codes or habitability codes, then the tenant should be able to move back in. And that has to be more than 30 days of not being able to do that. Otherwise your 30 days start over again. So if the tenant can move, technically move back in, and the permits maybe don't come through, or they say, oh, you got to pull down this drywall, and again, it is not something that the tenant could be in, your 30 days start over again of having to be consecutive. So you can't evict your tenant. Basically, you have to pay for them to move somewhere else or be somewhere in the meantime. They can't be evicted based on that.
Real quick, we do have a question from Allison.
Yeah.
She's asking, what's the max percentage of annual rent increase that is allowed?
That is a good question. I don't know.
Right? Very good question there, Allison.
Yeah. I don't remember. I could guess, but I don't know.
Yeah, we'll have to look that up for you, Allison.
Yeah.
Did they, Lauren, did they make any adjustments to the notice of, for example, if the lease is expired, it's gone month to month? I know if the tenant's been living there for more than a year, it's 60 days, right?
Mm-hmm. Mm-hmm.
And then if it's, just coming up on the 1 year, it's 30 days notice. But if you have had a tenant in the property for multiple years and, landlord owner wants to basically say, hey, I'm going to, do something
Right.
else to the property, I'm going to sell it or whatever, Did they address any of that, or is it still as a?
No, they didn't address that specifically, but they did state that the notice to terminate has to include a specific statutory notice that's written kind of verbatim per the law. So the notice that in the CAR form, they'll have that statutory notice written in there, but the landlord's required to provide that. They also have to explain to the tenant that the tenant has the right to re-rent at those same terms if the renovation isn't completed. And then they have to describe the remodeling that's to be completed. This is for the substantial remodeling eviction. They have to describe the remodeling that's going to be completed and the approximate expected duration. And they have to include a copy of any permits required for these renovations and notify the tenant if they want to reoccupy the property after it's remodeled. Obviously at whatever the revised rates are and things like that, they don't have a right to go re-rent it after it's remodeled on their existing terms, but they do have the first right of refusal to occupy the property. And if they want to do that, they have to give the owner their address, their phone number, and their email address so that they can be reached once the renovation is completed.
Cool. Hey, we do have a little note from Charles Barnes.
Yeah.
He says, as stated in AB 1482, every rental property in California that's not exempt from rent control can have an annual rent increase of 5% plus the percentage change in the cost of living, the CPI, this Consumer Price Index, per year.
Awesome. Thank you.
Yeah, thanks, Charles. That's awesome. And then another note from, I don't know who this agent is. It's just listed as P, but thank you, P. P says, California puts out landlord tenant handbook PDF that is followed strictly by California judges. Do a Google search for California landlord tenant handbook, and it is on the state of California website, updated all year. And that's Pam. Oh, hi, Pam.
Oh. Yeah, it's tricky. It's really, there's a lot to it. It's a whole other beast. And part of this law now specifically assigns actual damages to landlord violations of this act. So whether they're intentional or not, this can result in actual damages that the landlord has to pay, actual damages, attorney's fees and costs. They would have to pay up to 3 times the actual damages if the violation is considered willful. So if they can prove that it was done intentionally, like just to get them out of the property or something, and they violated this act, they can be liable for up to 3 times their actual damages. Punitive damages, and the attorney general is actually authorized to seek any kind of injunctive relief. So bottom line is, get a lawyer, get a real estate lawyer if you need to evict for any reason whatsoever, because it is messy and always changing. So
best. And then Albert also just says, are we as realtors supposed to keep track of the landlord's activities? No, we're not.
No, but when you're dealing, even if you're dealing with a buyer that is like, oh, I'm going to buy this for, to rent it out as an investment property or something like that, this is part of the conversation and advisement that you can provide to your clients of like, know what you're getting into. And, social media makes it look real easy to just buy a home and be a landlord, and, and there's a lot for sure.
Well said.
Okay. Okay, so now we're going to get into the new and revised forms. But before we do that, does anybody have any other questions about the laws that I just went over?
Had great questions today. So great discussion so far.
Okay. Well, if you think of anything, feel free to jump in. Okay. Okay. This is the one and only brand new form from that's being introduced, this release, and this is the Buyer Homeowners Insurance Advisory, or the BHIA. not to be confused with the BIA, which is the Buyer Inspection Advisory. And they are all going to be bundled together with the purchase agreement. So this should be interesting. People are going to get confused, but it will be bundled with the purchase agreement. So it'll automatically get added. It's just going to make that initial offer package that much bigger. But as you may or may not know, consumers are having a really difficult time obtaining or even maintaining certain types of homeowners insurance in certain areas of the state due to wildfire areas, flood areas. Those are probably the most common, but a lot of insurance companies are just taking that as an opportunity to just cut bait and get out. So it's really been a struggle. So the intent of this form is to advise the buyer upfront of the struggles in the insurance market, educate them on the importance of such coverage, and then explain their contractual rights as it pertains to the related contingency. Please remember, currently, insurability is part of the investigation contingency. So a lot of agents think that it's just a contingency for inspections. And oh my God, if I see another agent counter back with a shorter inspection contingency timeframe, I might lose my mind. There is no inspection contingency. It is investigation contingency. And it incorporates not just those physical inspections, but insurability and all of the other elements on that BIA form, the Buyer Inspection Advisory form. That's all part of that investigation contingency.
Lauren, that's a great point, because just the difference of the word means so much.
100%.
Inspection versus investigation. Investigation is all encompassing, and inspection is just one inspection of the property.
And it creates so much ambiguity because it's, we know what the agent means, but per the contracts, that's ambiguity. Are you saying that, okay, well, now they only have 5 days to do a physical inspection? Is that the inspection contingency you're talking about? Because that's how it's going to get applied. But it's currently being discussed by the Standard Forms Committee to pull this element out of that contingency and make it a standalone contingency. So the same way the review of seller disclosures is a standalone contingency, and reviewing the prelim is a standalone contingency.
Yeah, I would agree with that. To lump this in is makes it even more complicated and more likely for it to be have issues. I think if it's its own contingency, that will help agents.
So be careful when you're advising your client to remove this investigation contingency. Make sure that they have their insurance in place, because that is included. This is the buyer contingency removal form. The items that are in red show the updates from the June form release. That's when they separated and created a buyer contingency removal form and a seller contingency removal form. But anyway, you can see all of the ways that you can separate out elements of the investigation contingency. You can also see that there is no inspection contingency. The closest version of an inspection contingency would be C2 or 2C2. And that says the only part of the investigation related to inspections concerning physical attributes of the property. So not just when you're representing the buyer, filling out the offer, but when you're the listing side, countering back, and you want to shorten these timeframes. And then when you are on the buyer side, receiving a counter offer. If you get a counter offer from a listing agent that says inspection contingency 5 days, counter back and say, it's always recommended that you quote the actual sections in the contract and the actual paragraphs for what you're talking about instead of these general terms. Details matter, especially in this element. And then in C3, you can essentially do the opposite. So everything except the physical inspection. And then in C4 is where you can check either fire or flood insurance, or even other, if you want to pull out general homeowners insurance as like that part of the investigation. You remove everything except that. Okay. So this one isn't one that I mentioned in the agenda, but I wanted to throw it in here all the same. As you can see, this form is all red. And that's because it's been completely updated to match the updated HUD requirements. Just a quick reminder, this form is for FHA transactions only. It's actually a HUD requirement that the lender is supposed to provide the borrower or the buyer this notice. But CAR thought it was something that the buyer should have as soon as possible. So that's why when you check FHA in finance under the financing section in the purchase agreement, it will auto-populate and pull this form in along with that FVAC form. So it looks a little bit differently than it did previously. I mean, I've seen a lot of brokers require this form regardless, but it's not needed. It's really just for FHA transactions. So keep that in mind. It looks a little bit different, but if there is an FHA loan on the property, it should be part of that offer. Okay, this first transactional form is the seller property questionnaire, the SPQ. It's just getting 2 updates. First, there are a few questions regarding ADUs that were added to Section 8. It asks first if one exists, and then if so, has the ADU received a permit or other government approval? Mostly because if you don't have a permit or government approval, then you're not officially an ADU. And so a lot of people are running into throwing that terminology around, and it's not officially an ADU if you don't have that aspect, and that's important. And then also if there is,
we had an issue with that, Lauren, last year.
yeah,
it happens.
Yep, exactly. And then also if there is an ADU, are there separate utilities and meters? So both of these questions are important to the buyer. One, to be able to assess income potential and liability risk, but then also potentially to consider subdividing as it relates to that new ADU law we just talked about. The other update is to 18C, where they added a question about the property being originally constructed as a manufactured or a mobile home. Why? Because in an obvious case of purchasing a manufactured or mobile home, you would use the RPA, you would check that this is a mobile home, and you would incorporate the MHPA or the manufactured home purchase addendum to the contract. But if the physical structure has been permanently attached to the property, then technically all you need to use is just the purchase agreement. And there was really no way for the buyer to know if it was originally constructed as a manufactured or mobile home. So the seller should disclose this, and then obviously it's recommended that you should still use that MHPA form in the transaction as well. When in doubt, disclose. So okay, so this form, the seller's purchase of replacement property, this was updated in the spirit of equity, essentially, to match the buyer's version of this form, which is that COP form, contingency of buyer's property sale. In that form, the buyer has to provide proof to the seller that their home is under contract and requires the buyer to notify the seller if that transaction cancels. And so then the seller has the right to cancel based on either of those situations. And so now, this form essentially does the same thing, but in reverse. So the buyer technically can be concerned that the seller removes their contingency, but doesn't have any place to go. So now the buyer can require proof that they do in fact have somewhere to go. Proof of contract, of a lease, or any other written evidence. So if a parent is moving in with their child, something from the child saying, yeah, my parents are moving in with me, or like, yes, we do have somewhere to go. And of course, the buyer would want to know if the seller's replacement agreement falls through or fails, because then the buyer would be at risk. What if the seller doesn't want to move out? What if they then just drag their feet, delay closings? Like, the buyer has the right to want to feel comforted in knowing, like, yes, the seller is actually moving along and they're going to move out and leave. So my only issue with this form is that it's now 2 pages, and the second page is just literally the signature lines up at the top. So can't wait to see how many times that gets left off.
Exactly. Got a quick question by Tasha Wilmore.
Yeah.
She asks she says at the bottom of the HID, it mentions received by. Does it have to be initialed by the agent, or does it have to be sent to the housing department?
It says received by.
Yeah, I'm not sure.
I don't know.
That's a very good question, Tasha. You may want to contact Lauren individually.
Yeah.
You could kind of elaborate on your question.
Yeah.
And then one more, wouldn't the Albert asks, wouldn't the title clarify that? And I don't know. I'm sorry, Albert. I'm not sure what.
Wouldn't title clarify if it was previously a manufactured home or it may not. But it's always better to get it directly from the seller.
Good call.
Any of that information. Okay. We went over that. Yes. Okay. So this is the final transaction form we'll discuss, and it's the TOPA, or the tenant occupied property addendum. Remember, you have to use this form whether the tenant is going to stay or not. If there is a tenant on the property at the time an offer is made, you need to use this form. And this form now has 3 updates. So 1B3 was added because the rent control jurisdictions may have requirements for vacating that affect this new owner's rights. So in the case of the property being delivered vacant, it requires the seller to now disclose to the buyer when the property became vacant, whether the tenant vacated voluntarily, whether the seller paid the tenant to leave, whether the seller filed a lawsuit to attempt to evict the tenant, and if so, whether that lawsuit ended in a judgment. Because this is one of those situations of like, well, it's your problem now, you own the property. So the buyer needs to know, what are we walking into? What is the situation? How is the tenant? If the property is to be delivered vacant, how did you get it that way?
Yeah, this is a big one.
Yeah. They also added a third option, option C, to section 1, because the terms of the TOPA form aren't relevant if the tenant is the buyer. So you can just check that box and the buyer is a tenant. However, of course, if the property is like a multi-unit, then you have to carve out those exceptions, and the TOPA would apply to the other units and the other tenants, and not to the buyer of the property. So there's kind of that specific carve out, which we run into every once in a while, where it's like, oh, the buyer's buying it from the seller, or the tenant is buying it from the landlord. And then the last update is just a reminder that the seller is required to provide an itemized list of deductions to the security deposit upon return to the tenant. It's one of those things where it's like, we all know that that's what you should be doing, but because of some people, we now have to put this in writing. So that is the other update to that form. This is the first of those 3 property management lease documents we'll be talking about. And again, you could probably hop into this in more detail, talking about landlord tenant stuff, because it's beefy. But this is the residential lease, or the month-to-month rental agreement. There's 2 main updates. The first is in regards to pest control, because this is a maintenance aspect of the property and not necessarily an issue of habitability, right? So you're not saying like, oh, there's a pest problem. It's like there's just maintenance. In the same way, this question's actually asked of the seller by the buyer in the disclosures of like, do you have any regular maintenance? So this discloses it, and because it's like preventable, the forms committee determined that it could be something that the tenant could be required to pay. So that's why they're allowing who's going to pay. It's an allocation of costs in the same way of who's going to maintain the landscaping, who's going to, pay for what. So they added this pest control element. And then the other aspect is the liability issue, liability insurance requirement. So the liability insurance is optional. But if you check the box that the landlord does require the tenant to have liability insurance, what they were finding was that there was really difficulty adding the landlord or the housing provider as an additional insured. So what they've done is they've made the default be that if this box is checked, then the housing provider will be added as an additional interest. And then if possible, an additional insured. So the difference between the two, additional interest just is more like a position of being notified. So the landlord, it's really to protect the landlord. They will be notified if there's any claims filed, if it lapses, just kind of keeps them updated. And then obviously additional insured is another layer to that and a little bit more involved. But again, it's kind of difficult to do. So the default is that they are just an additional interest. Okay, and the other form is the application to rent. This was just added in on the last page of this form, and it involves the screening fee. And so if there is a fee being collected, then they just have to disclose the full amount being received. And also they've decided to come into the 21st century and allow the receipt for the screening fee to be provided by email, because previously it was not. It had to be delivered like a hard copy, personal or by mail. So now you could send it by email. So we're excited for that. And then this last one is the tenant estoppel form. And again, this one is an all red because they changed the entire thing. And I'm so excited because the last version was like a Mad Lib, like a fill in the blank. You're like reading this dense paragraph, trying to figure out what does and doesn't apply. And tenants had a hard time filling it out. Now this is in a grid form. And it is really easy to find the terms and figure out what doesn't apply, who pays what. They denoted animals on the property, what type of animals, so emotional support, service animals, anything else. And then who pays for utilities and services and things like that. And then there's also an additional section if you need to fill in kind of additional terms as well. Okay, and then these last ones are just kind of silent revisions. So CAR has a new policy now with their forms where they are not going to, all the forms have to be reviewed and or updated every 4 years. So they've gone through every single form in their forms library and have at least looked them over. If they didn't need any updates or changes, they changed the date on them at the bottom of when they're most recent, and then moved on. Or they made just kind of small, what they call silent revisions, little tweaks and changes to it. But this is really going to be helpful when you are receiving disclosures or documents or forms. You can look down at the bottom, and if it's more than the last 4 years, then you need to request an updated version of the form. There's previously, it's not a law, it's just helps with all of these documents and figuring out, who has the most updated version of the form. The other thing also to keep in mind, speaking of updated forms, is that the CAR user protection agreement does not apply to older versions of the forms. So one of the things that my team and I are kind of discussing is this update to the SPQ. Do we need to go back and have our sellers that signed an SPQ last week, do they need to fill out a new version of the SPQ? Is that old version not going to be protected? And my kind of unofficial approach is, if there's an ADU on the property or if it was a manufactured home, then yes, refill that form. But otherwise, kind of moving forward. But it's important to keep in mind, I've seen agents, especially when we redid the listing agreement and the purchase or the RPA, there were old versions of the RPA and both parties were like, oh, it's fine. It's not a big deal. It is a big deal. They don't protect anybody using those old forms. So make sure you're using the most up to date.
Especially the E&O.
Yeah, exactly. So the silent revisions revolving around the repair request, the RR, and the response, seller's response. For the RR, really, they just are kind of going full circle. Repair request used to be one form, And then they decided, well, we need a separate form for the seller to respond. And on the separate form, the seller could respond in a myriad of different ways. They could kind of partially respond to some of the buyer's requests and mix and match. And so then the members were like, well, we like some of those options for the partial response. So we want to put those options on the repair request. So now the responses available to the seller are the same on both versions of the form. So in theory, you could still use one version or one form, just use the repair request. You don't have to use the response. So whatever, it all comes full circle. Other little things, the TDS, they remove the seller initials on page 2 because the seller is signing page 2 and you technically don't need initials to make a valid contract. So the purchase agreement has initials on the bottom of every single page. Technically, you don't need those to make a contract. And anywhere where initials are required, there are separate designations. So liquidated damages, you have to initial. Mediation or arbitration, you have to initial. But otherwise, you don't really need them. So the SP, the single party compensation agreement, they actually made it so that the seller or the buyer can pay the compensation. So sometimes we have a for sale by owner situation where the buyer's paying all the fees, and that includes the commissions. And so now you have the option on that form to say, yes, the buyer's the one that's paying it. The AOAA form, that's the assignment of agreement addendum. If you are changing, adding a buyer, removing a buyer, anything like that, changing it from individuals to an LLC or a trust, they added phrasing that is the buyer has not and will not receive compensation for this assignment, because they were kind of running into that issue of like, well, maybe not right now, but like, will they? So they added that in, and that's important to note. The RPA, a lot of you may have experienced this default in the additional reports section where they had this fortress fire report. I have personal feelings about that report. I would not recommend it. But it was like a default. And so agents weren't noticing it. And we were getting contracts where it was like, we have to order this fortress fire report. It's kind of along the lines of like the clue report, where it's like, you're going to get this information anyway, and it's not helpful. So they fixed it so that it is not automatically selected, but it is an option from the drop down that you can request or have this report incorporated. And then the TOA, the text overflow addendum, that automatically generates anytime you start typing outside of a field. And so now they've just kind of updated it where they create a separate form for each different situation. So it used to be like buyer and seller, but what if you have a landlord or a tenant? And it's so now it looks correct and matches the fields that they have for their primary documents. I blew way past my 20 minutes, but as you can tell, it's a lot of information, and that's all I've got. So anybody have any questions?
Thank you so much, Lauren. Yeah, if we have any questions, we'll field them, but thank you so much for, keeping us up to speed. It's very helpful for me too, because you only can do so much and, retain so much. I know that we did cover a lot of material, but Kevin does send out the replay. So this might be one that if there's certain areas that you deal with investors or you deal with tenants a lot or landlords, you might want to go back and listen to those portions again. That might be helpful. And then Lauren, I wanted to let you plug your new service here. We had talked about that a few weeks ago.
Oh,
and
yes,
so
yes.
Before we let you go,
Yes.
please, give us a quick overview of what your company is doing now as a service to agents that you work with.
Yes. So our agents that we work with, we are offering a free service of our listing package preparation. So if you have a listing appointment that you're going to go on, you would fill out some general information in our online form. We will order a property profile report if you need it, and then we'll put together all of the necessary listing documentation. We'll add your client's contact information, if you know the dates, if you know the list price. We'll fill out all of that part of the listing package. We'll put it all together in one PDF and send that over to you. And so we have a quick same day turnaround time for that. And we offer that free to our agents. And then also starting in January, we are rolling out our deluxe listing management services. And it's the first of 3 tiers, but essentially this involves MLS input as a draft. We'll work with the seller to fill out any of the details on the MLS. So we'll have them let us know of their features and any kind of those little fields in the MLS that are required, but nobody really knows except the seller. We'll upload the property photos. We'll write the photo captions. We'll create a property description for the MLS. We'll set up open houses. We'll connect your lock boxes, kind of all things MLS in regards to that. So that is an additional $199 service that is payable up front when you submit the listing to us, and we get that uploaded and turned around for you. And then after we launch that service and kind of work out any bugs or kinks that there may be involved in that, then we're going to roll out additional levels of services that include, scheduling the photographer, the stager, the videographer, all of that stuff. Things like scheduling showings, following up with agents that have viewed the property, asking if they're going to write an offer, so on and so forth. So we're really leveling up our services that we're offering, and that's coming soon.
You're expanding.
Yeah, it's great.
Cool. So
Great.
if anybody,
Great service.
yeah. Well, a lot of people, including myself, when I do sell property, I don't enjoy doing MLS uploads. I don't think anybody else does either. So that's a great little niche that you're carving out, Lauren. So if anybody has questions about that, or if that sounds of interest, please reach out to Lauren. And we thank you so much, Lauren. Hope you have a great holiday. We'll look forward to bringing you back on next month with the buyer broker and agent agreement.
Yes. Same to you. I'm looking forward to it. Happy holidays, everybody. Happy New Year. And enjoy the rest of your week.
Yeah, thank you, Lauren. Appreciate it. Hope you have a great holiday season, and we will see you next year. All right, perfect. And I know we've gone a long way, but we do want to bring our rock star escrow officer, Raquel Bauer, on the line. Raquel, good morning. We just wanted to say hello to you and also congratulate you on a fantastic year. So many of our agents are now utilizing your service, and everybody's having an amazing response to the way that you handle your business. So thanks, Raquel, and hello.
Hello, good morning, everybody. Thank you for that. Appreciate it.
Oh yeah.
I just wanted to personally say, I wish everybody, I know that it's coming to the close here really quick. Christmas is just like a few days away, 5 days away. Say, have a wonderful and safe, if everybody's traveling, holiday, especially from myself and Legacy Escrow, of course. And wanted to thank everybody that has supported Legacy Escrow and myself in this last year with their business. And then, the joys of making these new connections and having these great, wonderful people. It's just amazing. It really is. I know there's a lot of choices out there for every agent to make. And I just really, really do appreciate you guys making that choice with Legacy Escrow and myself.
Yeah, well, the agents are extremely happy. And so it's been a great, great year. And again, we really thank you, Raquel.
Well, I want to say that. Tell Courtney I said Merry Christmas as well to you guys, Bill, and everybody else that I'm not going to see. And to the upper people, the management, the big wigs, have a very, very Merry Christmas and a safe travels. And I look forward to working with everybody again and any and all new agents in the upcoming new 2024 year.
Oh yeah, we're gonna make it happen, right?
Yes, absolutely. I'm ready for it.
All right. Well,
Awesome.
thank you very much, Raquel. Really.
Thanks, Raquel.
Thank you.
Okay,
right,
Kevin,
yeah,
let's
yes.
button this thing up.
Let's do it. All right. So we just got a couple more little closing deals. So Bill, you want to just let everybody know what the holiday schedule is going forward?
Yeah, so we'll get something out. Obviously, since Christmas is falling on Monday, we will be kind of closed, quasi closed as well as we can in our space. Lunchtime on Friday, and then we'll be back, midday on the 26th. So, that'll be a nice long weekend for everybody to, do what they do. And if they're celebrating Christmas, great. If not, that's great too. And then we will, since New Year's, I think falls on the same schedule, it'll be the same thing. So, I haven't double checked, Kevin. Have you looked at is Friday a holiday for typically? Maybe not, huh? Maybe just Monday.
Double check that. We've got it.
Because I think Christmas Eve is technically a holiday, but since it's falling on Sunday, I don't think it carries to Friday. But
Yeah.
anyways, that's kind of the plan. We'll be back in webinar early January, get back in on our fresh schedule for the upcoming year. And we just want to thank everybody for attending these webinars. It's a great place for us to get together every week to talk about these things that are in our industry that are changing. And, we really take pride on bringing good content and not wasting anybody's time. So we really appreciate that. We hope everyone has an amazing end of year and enjoy, have a time out or whatever the plans are. And let's come back refreshed in 2024. And with the rate environment and things looking up, I think it'll be a good year.
Absolutely, Bill. Well, agents, thanks for joining us. We always appreciate you guys spending time with us on a Wednesday and furthering your knowledge of the real estate world. So get out there, make it a great week, productive week, and we will see you guys next year. Thanks a lot. Bye-bye.